Wait. Your appearance, please.
Good morning, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Amari Sanders.
All right, what are we doing?
We reached a waiver resolution on this matter. My understanding is that the defendant is going to waive on both files with the agreement that on the file ending in 2162, there will be an offer extended in circuit court to plead to an added count 4 of unarmed robbery under FIDO, counts 1 through 3 to be dismissed upon taking that plea. And then on the CCW file ending in 2157, going to the waiver of and plea as charged under FIDO on that file.
That a correct statement?
That is true, Judge. I did communicate that to my client. He knows that the prosecutor is making a record today of the offer that will be available in circuit court. He understands that all his trial rights are still preserved, and he's willing to waive the exam, Judge.
Sir, you understand that you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution of both of these cases?
Yes.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 felony counts. Ms. Barnwell, your client waives formal reading, stands mute.
Yes, Judge.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial in these matters will be set
January 27th at 1:30.
January 27, 2025, 1:30 before Judge Conkey.
Thank you, Judge.
Thank you. Yes.
Let's pause and appreciate this efficiency. In under 5 minutes, 2 felony cases are bound over with all rights waived. This is a side of the justice system most people never see. Procedural, fast, and relentlessly forward-moving. But watch closely. That efficiency disappears the moment complexity enters a room.
Ms. Barnwell, were you ready on the Robinson matter?
I am here on the Robinson matter, Judge.
I know. Are you ready on that yet?
I am. I was having him sign the waiver.
Oh, okay.
Any information on the previous case?
On which one?
The previous case.
I won't buy it.
Oh,
You have them. The court does call the case of the people versus Malik Robbins.
good morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Malik Robinson.
Your name, sir? Malik Robinson. He's waiving.
Yes, Your Honor. There's an offer made here for that waiver to waive off and plead as charged on this matter in circuit court, as well as at the next hearing on his other felony matter. It's an Arno, except for this Thursday, he will be pleading to an attempt Arno as a global resolution on that one. And that file was 26F5-500FY.
That's set for PCC, or is that set before?
For PCC.
So that's going to be a waiver?
Yes, Judge.
That one's going to be a misdemeanor plea at PCC.
Got it. Okay. Then I won't try to do that today. All right. I was just going to try to get everything together for him. Oh, but we won't do that. That's, Ms. Barnwell, that's your understanding?
Yes, Judge.
Sir, you're waiving your right to a preliminary examination in this matter?
Yes, Your Honor.
All right. And you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we waive a reading of the information and stand mute.
Defendant having waived formal reading, standing mute as to both counts. Court will enter a not guilty plea. Pretrial will be set for
At 1:30 before Judge
March
March.
10th, 2026, 1:30 before Judge Kunke.
I didn't hear the name of that judge. You said Kunke?
Kunke. Yes.
Okay. Thank you, Judge. There's one more matter.
In this case,
Yes.
is it bond?
My client had, yes,
He's out.
I know, but there's a,
No.
he wants permission to travel.
To where?
So. he
So,
works-
no, so if I don't like the place, then no. No. Where's he want to go?
Your Honor, this is the situation. He works for Amazon. We all depend on them, right? Well, they're going in teams, traveling in teams
We
to different places out of state.
depend on Amazon? Yeah,
Practically.
yeah, pretty much.
To
Go ahead.
different places out of state.
Okay.
So he doesn't know exactly where now, but for the next 7 months, that's what they have to do. I guess that's why we get those packages so early.
Mine are always late. Where? No. On the one that's set for PCC. What is that charge?
Obstructing.
The PCC matters of resisting an obstruction charge.
Okay, because I have, the issue is that I have a bond violation technically on this one. That results, as I'm to understand, because he picked up the other ones.
I believe that's correct. I never received a bond violation report, so that was my understanding was the reason for the violation.
When is he supposed to start the
A week.
travel?
Your Honor, it's within a week that he's supposed to start.
Does he have, you have any documentation indicating that that's it, that you put your hands on today? Because
Emails.
here's the deal. If I don't deal with it today, right, then I lost jurisdiction on this case. And I can't do it. You follow me? So that's going to be my problem. Then you'll have to get that before it's chunky before you can do that.
No, I mean, they won't even tell me the information, but like, turn on my leg.
Hmm?
So they won't even give me the information, the rest of the information, because I
Now,
can my leg.
maybe the other alternative might be, well, you're up before me on Thursday, right?
Yes,
For
he's
the
here on the
update.
15th.
So can you put your hands on it by Thursday?
Yeah.
Huh?
Yes, Your Honor.
Okay.
Your Honor, the thing is, they didn't want to give him information because of the tether, because they see this as a
Hold up. This is the messy reality of bond conditions. Judge Simpson's hands are tied by missing information. He's being pragmatic. If I don't address it today, I lose jurisdiction, but you can feel the frustration underneath. This is a perfect snapshot of how real life, jobs, ankle monitors, logistics, collides with rigid courtroom procedure.
as an impossibility.
Who?
The
Amazon.
job, right?
Yeah.
Amazon.
What did it
That makes
say?
sense. Who the hell?
So basically, I need. So basically, with this tethering, they won't give me no information on where I'm going.
Where? So because you have the tether, they'll keep you employed, let you do whatever you're doing.
I've been seasonal. It's seasonal. I'm seasonal worker.
So hold it. Are you currently employed with them?
Yeah, I'm currently employed with them, but I'm going through a third party. We're going out of town. They just sending us out of town. They pay for everything.
I guess I'm not clear on this. So he's kind of employed, or he's employed by Amazon. Right. He's going to go do training out of state. right?
Correct.
But you don't have the information regarding that training,
No.
but you think you can by Thursday?
Yeah.
Okay, so here's, because I'm gonna need that to give travel permission on his other case in the event, right? So make sure when you come back on Thursday that you have that information that you can give counsel, okay?
Okay.
And then on this case, I guess since they don't have it, the best thing that,
Guess I could bring a motion, an emergency motion.
well, I think, or I don't know
Georgia,
if the people have an objection to it.
Your Honor, if I get proof of employment, I'd be more than happy to stip to allow travel for that purpose.
Yeah. So, but, and then you could step and then Judge Kunke could sign it, right? But I don't know when that would happen and if it doesn't happen in time for him to travel. So I know what I'll do. I'll do it this way.
Bound over
What is
means
that
trapped.
application number?
Skipping prelims? Risky. System wins.
5-5000.
5,000.
Yes,
So 26 at 5,000.
yes.
That's the one for Thursday.
Yes.
Yeah.
So I'm gonna do this. This kind of does it backwards, but I think will get us there as long as you can get the information to us on Thursday. Okay.
Okay, Your Honor.
So what I'll do is I'll continue as bond in this case. But in this case, I will indicate that the defendant may travel as permitted in case 26F5 for work purposes. So I've ordered that while I have jurisdiction in this case. It should carry over then when I order it in the other case, you'll have the same travel. Make sense?
Now, my next question is, can we zoom in for that? Or we have to be here physically?
See what I just did for her client?
You know what, Judge? I'm in Ann
No,
Arbor.
you see what I just did for her client? And then I
You know
do
what?
that, and I like you. She's wearing them in there. But
I'm in Ann Arbor on Thursday with Judge Slade. So
so
physically.
you were gonna go see Judge Slay and not me?
So
Oh,
I
no.
realized that.
No.
But if there is like the time conflict, I don't know if it'll be in the afternoon because he is, no, it's still in the morning.
It's at 3 p.m. on Thursday.
Is this? Oh, because it's a bond.
Or just be, no, he's just out of custody.
He's just out of custody.
Yeah.
On Thursday.
He's a good thing about that. No, it's Thursday.
Okay, all right, so what else do you want?
I'll be zooming.
I am trying to,
She was time to file a form. She looked
she has time to file the form. I do.
Oh, I have time up until tomorrow?
noon today.
So you got about an hour and 15 minutes.
Oh, my God.
Is he,
Okay.
is he gonna want to appear via Zoom also?
It could be.
Yeah, could be.
I can talk to people better when they're on Zoom and I'm on Zoom. When they're in the courtroom, it's like, it's unyoked, is
I
that?
like people in person. All right. Well, the problem is, he's gonna have to be here because he's gonna have to get me the form to
Paperwork.
stop, right? So I need him here. You fill out the form if you need to appear via Zoom if you're downtown.
Okay.
That was way longer than I needed to take with that at all. All right. So
Thank you, Judge.
you got that so that we can get your paperwork so I can take a look at all of that. Okay.
That's right.
All right.
Thank you.
All right, folks. Thank you.
I thought I gave the waiver form.
You did. We were trying to help you. All right, sir. You're good. Take care.
Thank you. Case number. Okay.
Darn well, you're killing me.
We're down to 3. Working on it.
That one's holding.
Yeah, the one coming back from.
Oh.
Yeah, that's the only one so far. This is Gaddy, but he's working on a resolution, it's not ready. So
Is that ready? That's the only
this
one.
is the only one that's ready. All right, I'll call. Do you want this performance secret?
Yeah.
Okay.
And
And then match the language that you put.
yes. Court does call the case of the people versus Joseph Hefner Cantor.
People. Thank you, Your Honor. Alex Warren Green on behalf of Mr. Hafner Cantor. Can you please speak your name?
Joseph Hafner Cantor.
All right.
This is the daytime set for preliminary examination. As it relates to counts 1 and 2, the people are unable to proceed. I would ask for remand. Your Honor, the defense would move to dismiss with respect to count 1 and 2.
Same court, justice slows when reality hits.
2 are dismissed. I'll continue his not guilty pleas as to counts 3 and 4. This will be set for pretrial on January 26, 2026. Time, I'm sorry. 1 p.m. before Judge Freshour. Bond continued.
Your Honor, may I be heard with respect to bond?
Yes.
Thank you, Your Honor. Mr. Hafner Cantor's bond was revoked at the last hearing he had before this court. Mr. Hafner Cantor had admitted to several SoberLink violations, including one that occurred at the same time he was in court for a misdemeanor OWI. And Your Honor, at that time, I think the argument we made was a little naive. I think we were asking this court to find that Mr. Hafner Cantor had had an epiphany and was going to cease drinking on his own volition. Since that time, I've had a discussion with Mr. Hafner Cantor about putting some safeguards in place to ensure that he does not begin drinking again. And Mr. Hafner Cantor admits that he does have an alcohol issue. Your Honor, Mr. Hafner Cantor, his SoberLink was previously, well, in the other case, a scram tether was ordered. But in addition to that, Mr. Hafner Cantor previously attended AA meetings at the St. Paul Church in Saline.
Can I just say something?
Yes, Your
Isn't
Honor.
he before Judge Freshour on the OWI?
That's correct, Your Honor. Yes, Your Honor.
And so it would seem to me that she might be better equipped if I just leave it where it is to deal with the violation here. Quite frankly, that's what I'm thinking.
I understand the court's position. I did talk to Mr. Hafner Cantor, and I think he knows that this case is now going to be remanded to the same judge. But
he does want me to ask the court to reconsider bond. It was initially set at $5,000 personal. I would ask the court to consider reinstating that. I know that a referral has been made in the OWI case to the district court sobriety court. And
Which also Judge Freshour handles.
that's correct, Your Honor. So I'd ask the court to consider it. But otherwise, we would renew our argument before Judge Freshour.
I am not, I don't need a response. People, I'm gonna deny your request. I'm gonna leave this bond as revoked. You can address all of that, the drug court as well as OW.
And here's a firm, essential boundary. Simpson clearly respects his attorney and seems sympathetic to the defendant's progress. But the violation is serious. He refuses to undercut the sentencing judge. This isn't coldness. It's institutional respect. Sometimes saying no is how the system protects its integrity.
Why everything, you can address it before Judge Freshour and let her make that decision.
Thank you, Your Honor.
Thank you.
Where's Mr. Gay? It's ready just yet.
Okay.
And
Pardon?
he,
I,
we wanted to get Mr. Gaddy.
no, that's okay, because I think you guys aren't ready yet.
I've been to that, haven't seen a deputy, he called him about 20 minutes ago, and it was about 20 minutes out, so he may.
Okay. And then that one's
Is
going.
Mr. Chabalowski and Mr. Kiloweld, and my understanding is this whole thing.
And where's Mr. Kilowalt?
Just going, I was just going to the exhibits with him.
Okay, you guys sort all that out, and then well, the court's in recess.
All right.
Well, yeah, because it's all about you. All right.
Want me to have it?
Sure. What?
I said I'm a pawn. I'm a mere pawn.
Great of you finally realize your station in life. No. All right.
May have been a long time coming, but it's also a long time no.
Billy Kilowalt.
Judge, just, we'll put this on the record, but I talked to Mr. Killawall. Due to the short time frame, I was only able to get 3 of the many witnesses that would otherwise be here. I think I can complete the case that has the CCW. Start the other case.
Got it. Court does call the cases of the people of the state of Michigan versus Donathan Smith. He's probably need to sit at the table.
Okay. Hal Chabalowski for the people.
Good morning, Robert Jacob on behalf of Donovan Smith, Donovan Smith.
All right. Okay. And is date time set for preliminary examination, both these matters?
There was a previous offer made to my client, which I took to my client to the jail, and I asked him again if he wanted to take advantage of a possible higher plea. Mr. Chabalowski, for the purpose of the record.
Judge, I did make an offer to the defendant alternative. He can plead, and I apologize. I don't.
I got it here, Alex.
Thanks. It would call for, in case number, so either would call for Mr. Smith to plead guilty to discharging a firearm at a building, the 10-year max. In case number 25 F21637 FY, with an agreement to sentence under HIDA, the Homes Youthful Training Act. And my office would then dismiss the remainder of the charges, which are an R&O, a 2-year max, constrained concealed weapon, 5-year max, and possession of a firearm by a prohibited person, also a 5-year max. Or Mr. Smith could plead guilty to resisting obstructing officer at 2-year max in case number 25F21637FY. And I wrote it as carrying a concealed weapon in case number 25FB2506FY, with an agreement to sentence under the Holmes Youthful Training Act and dismissal of the remaining charges, which were discharging a firearm in a building and possession of a firearm by a prohibited person. It's my understanding that Mr. Smith is not interested in that.
Mr. Smith, you and I went over those proposed plea agreements, right?
Before you go through and voir dire your client, I don't know, Mr. Killowell, did you voir dire him in the context of a probation violation that he has out of Wayne County?
I wasn't aware of that, no.
Okay. So my understanding is he has a probation violation. I'm not clear what for out of Wayne County.
I may be able to advise. To
Go ahead.
Court. At the time of both of these offenses, it is my understanding the defendant was on bond from an Oakland County case number 2529266FH. He had pled guilty, or he had pled, it says guilty plea on the ROA, the Register of Actions, to unlawful driving away of a motor vehicle. He was found guilty on September 4th, 2025. This incident date is like the 30th.
Pardon?
The incident date on these cases is the 30th
Of September.
2025.
But he was sentenced.
He was sentenced in November of 2025 for the UDAA on November 6th. So I don't think this would necessarily be a probation violation, but I don't know if the hold is just pending figuring out what's going on.
Well, the information that we received is that it's a probation violation and with no bond. But
the case that he's on probation in Wayne County for is the Oakland County case.
Is the
Yeah.
Oakland County?
It looks like he got transferred to Wayne County.
What are you on probation for? CCW on Ohio. You pled in Wayne County?
On a HIDA.
CCW.
Oh, I didn't have that.
When that was?
Sometime in 2024.
And I just wanted, I didn't want to cause any confusion. I just wanted to make sure that whatever conversation you had with your client about a possible resolution here was taking into account everything that he has. I was not aware of, I don't think I was aware of the Oakland County issues. We were just informed that he has a no bond hold in Wayne.
Judge, my client, I believe, did tell me at one of our visits at the jail, but nonetheless, he's not interested in the offers or anything like
Right. I just want to make sure that whatever conversation needs to happen happens, because I don't know what that's about. I can't see it to say why he has no bond on that case.
Be careful what you say, but if it's regarding that, what are you saying?
Stand up first, you're talking to. It's no bond because if I'm gonna be charged with CCW and shooting into a building, then that's of course violating my probation. So even if I take.
Right. No, I hear you, but is that the reason it's no bond is because of these cases?
Yes.
I see. Okay. So the deals you offered, that doesn't even make any sense. So, council approach was in this case, and I realize that there's been an offer extended. I realize what the defendant is saying now. Okay, young man, just listen to me for a second. And why I asked your attorney whether or not he knew about that is because that the Wayne County matter can have certain implications for you. Okay. But because your attorney doesn't know about that, he wouldn't have had reason to necessarily investigate what those implications are for you. Okay. And because of the way that the statute, the HIDA statute reads, as I see it right now, without going into all of the way things play out, you could end up with a number of convictions and no HIDA. Okay. I don't think that's what you want. Right. And that's what I was getting from what you said before about why you may want to do this. It may be, okay, and your attorney's going to check into this, that, and I'm just going to give you a hypothetical, okay? I'm not saying you're going to do this or anything. That if there's a plea in this case or in these cases, you could maintain a HIDA here, but then lose that one in Detroit. Then the question becomes, what happens to you? What's the probation department going to do? Okay. Otherwise, what you could do, you go through and fight these. If you get convicted, you would get, chances are you may not get HIDA on these, and then you lose that one there. Right? Which would not, I know you don't want that. Right? So, and I've just given you sort of a thumbnail of it. What I don't want to have happen is for you to be making that decision without a full discussion with your attorney who just found out about this. And he's going to at least have to make a phone call to try to figure out what's going to happen in Wayne. Yeah.
I don't want to make a waste of time. I don't agree to.
What?
I don't want to make a waste of time.
It's not a waste of time. He's got to advise you.
I don't want to.
He's got to advise you.
What the judge is saying, you can fight this case, but if you lose it, you can have. Detroit, you just saying that, you make a phone call, see what Detroit's going to do. You know, you want to fight these cases, but the judge wants to make sure you know the ramifications of Detroit decision in case you lose.
So I have a fair chance.
What?
So I have a fair chance to know what's going on.
Exactly. I mean, that the problem is this case came back, we set everything real quick, but then there's this other stuff out there. And, you know, part of my job is I got to be fair to the people, I got to be fair to you. And so and if I feel that something's not fair, I'm not going to head down that path. That's my job. Okay. So what I'm going to do, we can consider it, I'm going to find good cause given all of that. I'm going to adjourn the prelim today. Just listen. And here's the reason why. If I thought that was going to penalize you, I wouldn't do it. Problem is, you're not going to go anywhere anyway because you're on a no bond hold. They're going to keep you here. So if I thought it was going to keep you in, remember, I'm the one that gave you the bond I gave you, right? So I'm not trying to keep you anywhere. But I got to make sure that you know all of this stuff. Yeah.
If my mom talked to my PO, and if this makes it past prelim, then they're gonna come get me. But my PO is being fair with me.
Well, I don't know that they're going to come get you.
I'm telling you, she said that my PO said.
POs could say a lot of things about coming to get you. That's not necessarily whose decision it's going to be. All right. I'm just telling you. Young man, here's the thing. You're rushing, trying to make certain decisions. You got a brain, you need to think it through. You need to talk with your attorney to try to figure it out. I understand your mom may have had the conversation. I feel a lot more comfortable if your attorney had the conversation about what they intend to do.
You get convicted, he's worried about what the county's. You're not going anywhere because the county says. Mom's phone number.
And that's why, can I just say this? One of the reasons you're still here, because remember, the bonds I gave you, you could post and get out, right? Then you have to ask yourself, why are you still here? You're still here because of that Wayne County poll. Right. You're not going anywhere.
Right. They said,
Sorry. Go ahead.
they said, if my PO said this directly, if this is like made over to circuit court, then she's going to come get me. I'm gonna be violated for probation. And that's of course not making a deal as well. But I said, can she be fair? Can she please let me make it past preliminary exam? And if the charges are dropped, and she not violent, she said that she would.
But she didn't tell you that.
She told my mom that. My mom told me.
See, is your mama?
Your mom wants to know. Phone number, and I'll call her. Judge, while we're waiting, there's one other matter. You were gracious enough to give this young man a PR bond. We all expected him to get out.
Released. I'll set it. I'll just.
$100 bond?
Yeah, I'll just make it $100 bond. So he's getting credit.
That's
You
on,
understand that, young man?
that's on case 25.
See, this is why you need to. You've got a very good, very experienced attorney. You need to listen to him. Okay? Because I think you're making decisions based upon what you see and not understanding everything. All right, that's what I'm seeing. So the reason that he's asking for the bond, I gave you a PR on the one case. Since you could be released on that case without posting it all, right? You're not getting credit on that case for the time that you're in. So what he's asking me to do is to give you a nominal bond of $100 so that you at least are getting credit while you're sitting there. Follow that? Okay. My next date that I have, and I can, which is when it would have been set, other than trying to get everything set, is February 3rd. Will that work for Mr. Trebolowski? Will that work for your witnesses? All right.
Jill, that he not be released to Wayne County? Is that possible?
I typically don't get involved in that. So it's usually that they won't release him. Wayne County's not going to come and get him because they know where he is. They put their hold in. Once we're done, then they're going to come get him. We done. I don't know where in the process they're looking at trying to do that.
One last question. I think that's what to say. think the judge is saying that because you haven't been adjudicated, if there's any movement on this case, when you not sit, let you sit here.
They're not, because they can't. That's what I'm doing. And I'm just doing it. Quite frankly, you need to start listening to folks. And when I'm saying that, young man, you need to start listening to folks that have law degrees. You're listening to somebody else, right? And you need to start listening to that man sitting next to you about what you should do next. Because right now, as I see it, and what you're telling, you're making all the wrong calls. I gave him the 25 personal on the
Yeah.
W. I'm going to change that bond to $100 cash as surety. I'm going to adjourn the preliminary examination to February 3rd, 2026 at 9 a.m. Let you check all of that information out. And I don't have a problem going forth, but let him do it with everything in front of him as to what's going to happen.
Sure, to February 3rd, Judge, 9 a.m.
9 a.m. before me on both cases. Yes, sir.
Are you able to make the $100, the change to the $100 effective last week, Thursday, so he gets all his credit? It's like it's 4 days, but it's 4 days. It should, I don't know if it is, or we just have to fix it later.
Judge, this young man is saying he gave PR bonds on both cases. I don't recall that.
No, I didn't give him a PR on the
50,000, 10%.
right. I gave him. Well, no, I see it. I did. I gave him a PR on both cases. That's so he shouldn't even be here right now.
I thought you had left the 50-10%.
No, I'm looking at the Caro, and it was $25,000 personal recognizance on that one, and on the other one, well, no, something's wrong here. That's not right. I think they got the wrong.
I thought you said
They got the wrong amount. What do you have on that bond? The 1637 should have been left the same because you said that you could post that one. That was the one I had already used. The new charge that came up was it was the court's intent to do the PR. Correct. And so on 1637, that bond should have been the 50,000 cash surety because he was going to be able to post that. So bond will be continued on that case, that being 1637 at 50,000 cash surety. That case, because that's the one that he could post, right? In the other case, what I'll do is I'll increase his bond to $100 cash surety, and I'll do the bond. We were here on Thursday. What day was that? 8th. Non-protunct to January 8th. So he'll get the 4 days credit on that since he hasn't been released.
Judge, on the first case, is it 50,000 or is it?
It's 50,000 cash surety.
No, you took away the 10%.
It was, I don't think it was 10% before.
Yeah. Well, that's what we really did. Straightforward. I just want to make sure I heard you.
Hang on a second. Let me just,
From Christmas, the 23rd.
let me make sure, because it should have been a bond form in here.
On the 23rd, I had.
What do you have on the 23rd? That's where I'm gonna put it. Those bonds should have been $50,000, 10%. And then his bond will continue at the $50,000, 10%. I knew he had to post, I knew to post it was gonna be 5,000. That's what I knew. So that will be the 10% bond on that one. The other one raising to $100 so they can be credit retroactive to the 8th. Yeah,
I can't post that the first bond anymore. Sorry.
No, don't be sorry. You can't post it. Give him credit. You should not post it. You know what I'm saying? That's how bond works. If he said it bond. You know. We give credit now every day on both cases. You understand what posting bond means? That $50,000, 10%. Right, you can't do that. So in return, you know, while you're sitting in jail, you get credit. You can't post.
Same court, justice slows when reality hits.
all right. Thank you. We'll see you in a couple of weeks after they check on everything, young man. Thank you.
Thank you, Judge, for your consideration.
Court does call the case of the People's State of Michigan versus Marchand Smith.
Andrew Childers, appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Smith, is making his way to the public.
Take your hands out of your pockets. All right. I have your name, sir.
Marchand Smith.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of attempted resisting an obstructed 1-year offense. On a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Judge.
All right. Have him sworn.
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God?
Okay, I do.
Lower your hand, state, and then spell your name.
Marchand Duell Smith, Marchand Duellsmith.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that? You need your help. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. Do you understand that?
Yes, I do.
Still wish to plead guilty?
To get this situation over with, Your Honor, like I mean to get this situation over with.
Your Honor, we're perfectly ready to hold an exam if Mr. Smith does not wish to plead guilty. I don't want him pleading guilty simply to get something over with. If he wishes to plead guilty, I'm happy to stand here next to him and do that. But if he doesn't, then I'm happy to hold the exam.
What do you want to do, young man?
Is it possible for at least for the month that I spent in there, I spent over at least 35 days in there trying to get out on personal bonds. Then, you know what I'm saying, ended up with a personal bond on the 8th, didn't get out on the 8th, just got out yesterday. Like
you're talking about sentencing as opposed to the plea.
I mean, yes, if I can get time credit for the time that I did spend.
I can't, I'm not the sentencing, so I can't say I'm going to give you credit for time served.
And I have explained to him that he will get credit for the days he
Right.
spent against any jail sentence, which I'm not anticipating here, but there's no promise from the prosecutor or, obviously you can't bind Judge Washington, but I've explained to him that he would certainly get credit for the time he's there, but there's no promise of a credit for time served only sentence.
But if I do proceed with the proceedings, then
if you what now?
Say now, if I do proceed with the proceedings, then I would get what? Like,
You mean with a preliminary exam? If you do that, what are you? I'm trying to figure out what you're asking.
if I do, take the preliminary exam, I mean, what would happen? What would go?
Well, I don't think anybody can say what will happen, but if the people show their case, you'd be bound over to circuit court, and you'd then go to appear on what effectively is what's called a high court misdemeanor or felony charge before Judge Conkey.
Governor, if I may, we made the misdemeanor offer that is available for Mr. Smith today. I cannot promise that that offer will be made again in circuit court.
Listen, young man.
This is the ultimate test of judicial patience. The defendant is fixated on time served, but Simpson refuses to make promises he can't guarantee. Instead, he uses time itself as a tool. I'm going to step off for 15 minutes. It's a subtle power move designed to slow things down and prevent a rushed, irreversible plea. That's justice exercise with restraint.
Again, like I said, I have to make sure that folks understand what they're doing and whatever. So here's what I'm going to do. I know exactly where we left off in this plea. I'm going to step off for 15 minutes. I'm going to let you have another conversation with your attorney and then decide what you want to do. Okay? They've got their witnesses here. Everybody's ready to go. Or you can take the plea or not listen to me and start walking away. All right. Okay, court's going to stand in recess.
All right, 48 District Court's back in session. The Honorable District Simpson presiding.
You may be seated. I'm sorry. Court recalls case people versus Marshan Smith.
Yeah.
Michael Gaddy, Assistant Public Defender for Mr. Smith. State your name, Mr. Smith.
Marshan Smith.
All right, Mr. Smith, we had just begun the taking of the plea. You had been sworn. We're changing this.
No, Your Honor. I believe I've had a chance to speak with Mr. Smith. I have gone over his right to an exam with him. I believe he wants to proceed with the plea, Judge.
All right. So, sir, understanding all of what I previously told you, do you still wish to plead guilty to this charge?
I plead no contest. Yes. Is that what I'm supposed to plead, or no? I'm not guilty.
Well, what is?
I thought you were going to plead guilty.
Oh yes, I mean guilty. I'm sorry. My bad. Yes.
Okay, so you're going to plead guilty to this charge?
Yes.
All right. So to the charge of attempted resisting and obstructing a police officer, how do you plead?
I plead guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
Yes?
Yes.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Okay, I need you to look at paragraph 5. You'll see a copy on the podium. Now, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
Get the date. Do I have, hang on a quick second. No. On the date of December 9th, 2025, at the location of 456 Haynes Street in Ypsilanti Township, Washtenaw County, State of Michigan. Did you come into contact with a sheriff deputy?
Yes, I did.
All right. And what happened?
I mean, I could start, you know what I'm saying, from when I got out of jail that day. I did receive tried to call for a simple standby. I guess, you know, something in that didn't happen to where I was able to go to the place. But when I went to my place, you know, I was greeted by the officer. He did tell me to stop, and I didn't stop. I ran.
Okay, so the officer was there. This is a place you weren't supposed to be without a civil standby, right?
I mean, yeah, I did.
Okay.
For a civil
And so you
standby.
got there and the deputy, you were starting to proceed to it and the deputy told you to stop.
Yes.
And you'd admit that the deputy telling you to stop, that was a lawful command and he was performing his job in doing that, right? And you failed to follow his order or his command.
Yes.
Correct? Okay. All right. Sir, I do have to advise you that from the time that I accept your plea to the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would not be, you would not be able to withdraw your plea, and the court would not be obligated to follow any sentence evaluation or recommendation. Do you understand that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, not from the defense, Judge.
And have I complied with the court?
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
February 19th at 10 a.m. before Judge Washington.
February 19th, 2026, 10 a.m.
Yes.
10 a.m.
And
before Judge Washington. Yes, sir.
where is Judge Washington's court? Is this the same building?
No, it's not in this building. It's over off of Huron River Drive in Ypsilanti Township.
I'm not.
Okay, what happened is you can call over to the court. I think it's on that sheet, the 14B.
Is that by a Kroger's, if I'm
Yep.
not mistaken?
The Kroger's and
Is the post office right there?
yep,
Okay.
you know where you,
I know. Where,
yep,
yeah.
that's the
Because we had to go get our mail. We stayed in Arbor One in there. Yeah.
got it.
Yeah,
Okay, yep, it's that court right down the street. Okay,
sir.
all right, thank you, sir.
February 19th at 10 a.m. Okay,
Yes.
I got it on here. Thank you.
Okay, thank you.
Call that number.